Hey class, welcome to week 6 of Environmental and All Hazards Management Law. So last week we talked about basically policy implementation. So agencies go through rulemaking and then they begin to implement policy. And then today we're going to talk about how agencies enforce policies. And that includes both the statutes that give agencies authority and the regulations that agencies themselves create. So this lecture is going to cover some enforcement strategies, and primarily that's going to be about information collection, record keeping and reporting. We're going to talk about agency investigations, which actually have some parallels to criminal law. And we're going to talk about agency hearings, both formal and informal adjudications. So our textbook, the chapter that you had to read today, it does include civil and criminal lawsuits, and it talks about the issues of standing. But we're going to actually focus on those topics in more depth a bit later this semester. So this week, this lecture is just going to focus on the actual agency enforcement of laws and regulations, not judicial enforcement. As we go through the lecture, I do want you to sort of keep in mind these parallels to criminal law. Because the regulatory schemes of our administrative agencies do mirror our criminal justice system. So if you work at an agency and you're involved in investigations or hearings or tests and inspections, you're going to have to be aware of restrictions imposed by the Fourth Amendment and Fifth Amendment. And then you'll also need to know that parallel proceedings, they can't be used. So you can't have an administrative proceeding that is then paralleled into a criminal proceeding. Basically, the government can't use the administrative process as a loophole to circumvent the additional constitutional protections that attach to the criminal process. All right, so here we go. Information collection and agency investigations. So why do agencies even need to collect information? Well, basically, it's essential to the agency's ability to make decisions. Agencies depend on information when creating regulations, when adjudicating cases, and just generally carrying out their mandates. Agencies also require information so that they can properly monitor compliance with laws and regulations. It also helps the public that we've got informed agencies, because the better informed the agency, we hope, the better decisions the agency can make in the public interest. And private organizations also benefit from proper record keeping because, as an attorney, I tend to think that a complete, comprehensive, and well-maintained record system, assuming that you're not, engaged in illegal activity, but if you're maintaining a good record system and you've got your information together, that's a real big CYA if somebody comes to audit you. It's a good way of showing that you understand, the gravity of your industry and that you're trying to comply the best you can. So because there is so much need for information, this basically means that record keeping and reporting are major parts of life in an agency. So individuals, businesses, nonprofits, universities, all of these entities have to collect information about themselves and maintain those records in a prescribed format. Now, most agencies have pretty broad informal authority to require record keeping and reporting, but there's also formal authority to require these activities, and primarily that's given to regulatory agencies, like the EPA. So the Administrative Procedure Act doesn't actually provide any of this authority. It just says that other statutes or regulations can allow an agency to engage in information collection. And agencies generally require record keeping and or reporting if they've got your jurisdiction over the entity and the subject matter. Their requirement is reasonable, it's not overly burdensome on the entity, and the information they're collecting is not privileged. We always look to the agency's enabling statute or another controlling statute, basically to define the agency's jurisdiction. Like I said back at the beginning, that's that sandbox that Congress creates in which the agencies play. And agencies, for information collection purposes, tend to pretty broadly interpret their jurisdiction, and the courts do usually agree with them, again, so long as the record keeping and reporting requirements are reasonable. Now, organizations can be excused from complying if the cost is extremely high, or if it is somehow going to suffer a harm as a result of compliance. So a single organization more than likely has to engage in both record keeping and reporting. And this isn't just for situations where an agency thinks that an organization might be non-compliant. Reporting is frequently required just sort of in the normal course of agency business, and it's actually a way for organizations to show the agency that they are compliant with the law. So for example, public drinking water systems, they've got to keep records. And the image to the left there is the EPA's reference guide, so that these systems understand the records that they have to keep, what legal authority requires them to keep these records, and for how long they have to keep those records. So for instance, if they want to do a microbiological analysis of drinking water, they've got to keep that record for at least 5 years. And that's pretty standard. Federal record retention requirements are usually somewhere between 3 and 10 years, but there are always exceptions. So that is the record keeping, but these same public drinking water systems also have to report out to the EPA. So for example, the National Pollutant Discharge Elimination System, that actually requires cities and industries and other facilities to file discharge monitoring reports and reports of a notice of intent to discharge. So those are proactive filings. Now, the cost of reporting, it can be high, particularly for small businesses, which alone they spend almost 1 billion with a B, hours, and $100 million per year filling out federal government forms. So for instance, if you've got a basic research grant from the Department of Agriculture, you're going to have to file, if the university gets these, we file monthly, quarterly, yearly, and final financial reports. We have to file yearly audited financial statements, usually monthly, quarterly, annual, and final progress reports. So these are the technical performance reports. We have to file annual lobbying reports, annual and final property reports. We have to report on any subcontractors. We have to report on anything that we procured, goods or services from vendors. And we have to also report on our efforts to utilize small and disadvantaged businesses. And we've got to keep those records for, again, 3 to 10 years after they are last modified and used. So the costs of reporting, they definitely can be high, and it can cause an administrative burden. There are, however, benefits of reporting. Compliance saves money. So EPA, businesses spent a little over $500 million to comply with the Clean Air Act, but that saved $41 trillion in healthcare costs. Organizations spend about $65 billion a year to comply with the Clean Air Act amendments, but the economic value of that compliance pumps $2 trillion per year into the economy. And organizations can avoid lengthy and costly audits by properly engaging in record keeping and by properly reporting out. So there is a cost to reporting, but there are many benefits, and honestly, we tend to recoup a lot more money than we spend on reporting. So it's got a really good return on investment. Now, let's talk a little bit about privileged information, because I noted a bit earlier that agencies did not have to turn over privileged information. Mostly we're talking about trade secrets, and trade secrets are information, and that can include formulas, patterns, programs, devices, methods, techniques, or processes, but basically it's information that has independent economic value to the company or to the person who knows it, and also the company or person who owns that trade secret has gone through an effort to maintain the secrecy. So that's why, for example, if the local health inspector goes to KFC, they can require that KFC to hand over records, like food delivery schedules and cleaning schedules and all that, but can't force them to give up the Colonel's secret recipe, because that information is a privileged trade secret. Protections for this type of privileged information, they come to us from the U.S. Constitution, from state constitutions, from statutes and also the common law, so judge-made law. And those common law privileges can vary by jurisdiction unless, of course, the U.S. Supreme Court is the one who issued the holding. Back in 1996, Congress passed the Economic Espionage Act to criminalize certain types of trade secret misappropriations, basically theft. And if somebody engages in theft of a trade secret for the benefit of a foreign power, the individuals can actually be put in prison for up to 15 years and be fined up to $500,000 per offense. If it's a company that does it, you can't put a company in prison, but you can fine them up to $10 million. The fines are a bit lower if you have stolen a trade secret for use within the U.S., but still, they're good fines. There's also the Uniform Trade Secrets Act. So that's a model code. It's been adopted by 47 states. And the states that haven't adopted it have, similar laws that do protect trade secrets. Then there's the Defend Trade Secrets Act. That's another federal law. And that allows an owner of a trade secret to sue in federal court if somebody steals their secret. Now, there are also mentions of trade secret exemptions in other statutes. For instance, the Federal Insecticide, Fungicide, and Rodenticide Act, plus all of its amendments and various related statutes, it recognizes the trade secret exemption. And it protects trade secrets in the record-keeping and reporting process, basically by allowing organizations that are required to submit data to clearly mark portions of that data, portions of those records that contain trade secrets or confidential financial data. And when they submit that data to the EPA, they can actually break out the marked confidential portions from the rest of the report that they have to file. And that's really just to lessen the chance that the EPA will accidentally disclose the information. And the EPA is required by law to protect most trade secrets and then other confidential information from public disclosure. And we'll talk about that a bit when we talk about FOIA later in the course. Now, toxic chemicals can be protected as trade secrets, but it's not as easy as protecting KFC's, Colonel's famous recipe. If a company is going to assert that like a chemical compound or some other type of hazardous chemical is its trade secret, the company has to prove that the actual chemical composition really is secret. And that's pretty challenging today because with, gas chromatography and mass spectrometry and other tests, it's pretty easy to get a good readout on chemical testing and even reverse engineer it without breaking any laws. And so because of that, it's pretty doubtful that a company would be able to say that, well, this chemical compound is a trade secret. Now, there are, of course, times when that is true. For instance, Goreflex, when they first started some of their proprietary fabrics, they did have chemical compounds in there. And when they had to report on those, they could keep them, confidential. So the government couldn't release that information. However, if we're talking about toxic tort cases, which is what a civil action is about, if chemicals might have caused the plaintiff's injury, they're not going to be protected by trade secret laws or any type of common law doctrine on privilege. And this first came up in California in the early 1920s, and California's high court said, the right of the manufacturer to protect trade secrets, that's got to yield to the right of an innocent person who suffered injury, and primarily, more than likely because of the negligence of that manufacturer. So you can't keep it a secret if it's going to injure somebody or if it does injure somebody. Additionally, we've got the Emergency Planning and Community Right to Know Act, which is a federal law. This was created as a result of 2 Union Carbide disasters, one of which was in India and one in West Virginia. And the one in India in December of 1984, this Union Carbide plant, it released a chemical called MIC into the air. And that chemical is used in the manufacture of pesticides, and it's a lethal chemical. And that gas kind of silently diffused all around the town where it was released and killed about 5,000 people and injured at least 50,000 more. The only other place in the world where Union Carbide was manufacturing MIC was in West Virginia. So after the disaster in India, Union Carbide did shut down its West Virginia plant and put in $500 million worth of safety improvements. But even so, the very next year, they had another toxic release. It leaked from the West Virginia plant. Nobody was killed, fortunately, but 134 people were injured. So while the disaster in India was far more horrific, it was the West Virginia incident, plus about 7,000 other recorded chemical incidents in the U.S. In the first half of the 1980s, that really prompted Congress to pass the Emergency Planning and Community Right to Know Act. And the purpose of that act is to encourage and support emergency planning for when local, emergency responders have to respond to chemical accidents, and to provide both local governments and the public with information about the types of chemical hazards that might be in their communities. So any organization that works with chemicals that EPA lists as extremely hazardous substances, they've got to maintain these safety data sheets. Sometimes they're called material safety data sheets. They've got to maintain those for each hazardous substance, and they've got to provide those data sheets to the public upon request. In addition, they have to report more information about their hazardous chemicals to the EPA, to the State Emergency Response Commission, and also to the local Emergency Response Commission. The Emergency Planning Community Right to Know Act, it does offer some trade secret protections, but a state governor, a State Emergency Response Commission, or the EPA administrator can disclose to the public really any adverse health and environmental effects of chemicals, even if they are trade secrets. That act also permits the EPA administrator to determine that a specific chemical substance is not going to be considered a trade secret, no matter what the company says. And finally, even if the EPA agrees that a particular chemical compound is a trade secret, the organization that produces that compound has to hand over complete information to healthcare professionals if somebody is suffering an adverse effect that might be a result of exposure to that chemical. In addition to the Emergency Planning and Community Right to Know Act, OSHA has a hazard communication standard in the CFR, and that basically requires organizations to communicate specific information about hazardous substances to their employees. So Emergency Planning and Community Right to Know Act is outward-looking from the organization. The OSHA standards are inward-looking. The organization has to have a comprehensive hazard communication program, and that's got to include specific labels on containers, various warning forms, data sheets, and also employee training. Now, privileged communication, it's a legal principle that primarily restricts certain people who are in positions of trust from violating that trust. So if you've watched Law and Order or other cop shows on TV, you've probably seen a situation in which a priest can't be made to tell what somebody told him in a confessional, or a doctor can't reveal a patient's condition. So most of these forms of privilege come to us from the common law. So they are created by courts, but almost all states have created similar statutory protections. Privilege comes up most often in court when somebody fails to testify. And if you refuse to testify in court, and you're not a defendant in a criminal case, you can be held in contempt if you've been ordered to testify. But some communications are considered privileged, and so you wouldn't be held in contempt and you wouldn't be permitted to testify. And that's attorney-client privilege. There's also an accountant-client privilege, spousal privilege, religious professional privilege, which usually is called the priest-penitent privilege. Doctor-patient, I can't recall if I said that, and then other health professionals, including psychiatrists, psychologists, and therapists, also have privilege depending on jurisdiction. It's important to understand that the privilege is for the protection of the person who is divulging confidential information, not the person who is receiving the information. So if I've got a client and we're in a divorce case and she tells me that she's cheating on her husband, I can't reveal that information, even if I want to, because the privilege belongs to my client. And if you think about it, if these kinds of conversations weren't privileged, then nobody would feel safe talking confidentially to a trusted professional. And in terms of environmental law and emergency management, the most important thing is that you can talk truthfully to your attorney, because I cannot stress enough how important it is to be honest, complete, and accurate with your attorneys, because that's the only way that they can really help you. So to be privileged, the communication has to be between the person and that professional advisor. So for instance, the client and the attorney. I, as an attorney, have to be acting in my capacity as a professional. If my client is also a friend and she's chit-chatting with me in a bar about, infidelity, that's probably not going to be privileged. The information also has to be kept in confidence by both parties. So if either me or my client reveals, when she told me she was cheating, that privilege is going to be lost. And that sort of breach of confidence can be intentional, but it can also be accidental. And attorneys are often told in law school, be careful about what you say on an elevator. Particularly, if you're in a building where it's more than your law firm, you don't want to talk about a case in an elevator because members of the public could be there, opposing counsel could be there. Same on public transportation. I'm always shocked on the DC Metro how many attorneys are looking through what I would consider to be privileged documents, and they're just doing it in public. And the privilege does not apply if that communication gets out into the public. There are a few other instances where privilege can be waived by the court, and that is usually if the person's in danger of harming himself or others, or if the person is a minor and you want to let the parents know information, and then of course if the person is involved in criminal activity. So there are ways to kind of pierce privilege, but those common law forms of privilege really are with us, and it is attorney-client privilege that is the most important for agencies and for regulated organizations, really for all organizations. But for environmental law and emergency planning, it's the attorney-client privilege that is most necessary to understand. There is also the Fifth Amendment privilege against self-incrimination. So an individual can't be forced by the government to provide information that would then be used to prove that person's guilt. There are times, however, that agencies might require individuals to keep or provide incriminating records, and medical marijuana records for patients and for caregivers are one of the ones that have come up a lot. So to claim a privilege, you've got to be able to believe that the information might be used in criminal prosecution. So if you're in a state where there's medical marijuana and the state law says, hey, your dispensaries and the state commission cannot give these records to law enforcement, then you don't have any reasonable belief that you're going to be prosecuted. So you can't claim privilege, but on the other hand, the government can't prosecute you, not the state one anyway. You would be able to claim privilege if you were concerned about federal prosecution. Now, the Fifth Amendment privilege, it does not apply to business entities, this particular privilege. It does not apply to information that is in the possession of a third party, legitimately in their possession, and it does not apply to the voluntary collection of incriminating information. The mafia actually keeps really great records, and sometimes those get used against specific mob members at trial. The information is incriminating, but it's admissible because the government didn't compel the mafia to keep records. Now, agencies, they collect information, and then they also monitor compliance through tests and inspections. And that's primarily to monitor compliance with laws and regulations that protect our health and welfare. So for example, the EPA can conduct scientific tests of toxic disposal facilities. It can also, conduct tests of lakes and rivers downstream from those facilities or from mines or power plants. Agencies can conduct inspections to view records. So this is sort of the fruit of the record-keeping requirement. They can also come and review your physical premises to see in what condition it is in. And on a personal level, you probably know about that from HOA inspections, code violations, things like that. So it's often a local government issue for us as just kind of run-of-the-mill individuals, but it's a much bigger deal for regulated industries, primarily the ones who have to comply with environmental laws. Agencies have to be authorized by statute to conduct tests and inspections, so they can't just decide to do it on their own. Fortunately for organizations, inspections don't really cause any significant monetary expenses, but they do represent an invasion of privacy, and that is its own cost. So again, to parallel with criminal law, there are Fourth Amendment implications for agency inspections, because they are searches, for the most part, under the Fourth Amendment. And that means that they must be reasonable, and they more than likely need a warrant that is based on a legitimate cause. So in criminal law, the police can only get a warrant based on probable cause, but that standard is relaxed in administrative searches. Agencies just have to have a valid public interest in enforcing regulations via a search or an inspection. They do have to get administrative warrants. In criminal law, the warrant must state the very particular place to be searched and what you are going to seize. But again, in administrative searches, we relax the standard. Agencies basically just have to provide information about the area that they want to search and the agency official who is conducting the search. Now, not all inspections are searches. Inspections can be an observation made by agency officials in a public place. That's not a search, because being in public, you don't have any reasonable expectation of privacy. And that's the same in criminal law and administrative law. An inspection turns into a search when an agency official inspects an area in which the owner or occupant does have a reasonable expectation of privacy. So a private office, you're going to need a warrant, even though you might be in a public place, such as a restaurant. And if agency officials do not have warrants, then that search is going to be void, basically, unless the individual or organization consented to the search. Now, warrants, administrative search warrants, can be issued without legitimate cause if the legislature established reasonable inspection standards and the business where the search is taking place is a closely regulated business. So those are two exceptions to having to have an administrative warrant. So businesses within industries that are subject to significant licensing, permitting, reporting, and disclosure requirements, or required operating procedures or other specific regulations, those are closely regulated businesses. And that would be nuclear power plants, liquor stores, gun stores. Restaurants are closely regulated because of the vast impact on public health that they can have. And then also companies that produce chemicals, hazardous waste, all of those are closely regulated. And that's because there is a significant public interest, usually public safety, that merits special attention from the government. And so agencies can inspect these businesses without getting an administrative warrant, as long as the government's got a substantial interest in the industry. The warrantless inspection furthers that interest, and the legislature's got this reasonable statutory scheme that substitutes for the warrant. And that's basically something that has to be fair and narrowly tailored to achieve the government's interests. So you don't need a warrant to go search a nuclear power plant or a chemical plant that's discharging toxins into the water. But you would have to have a warrant to go and search your local Macy's. And this is to mirror the public safety or exigent circumstances exceptions in criminal law. Basically, the time spent obtaining the warrant might put the public at risk, or it might make it impossible to obtain evidence. And so that's why the warrant is not required. And closely regulated businesses know this from the outset, because they do understand this sort of inspection standards. So again, an agency can search an area without a legitimate cause and without a warrant if the legislature established reasonable inspection standards. And these have to be inspections that are vital to an agency's ability to enforce compliance with like health, safety, sanitation, and similar laws. Like I said, you can get this area warrant that allows an agency to just take a look at a general area. And the reasonable statutory scheme, it has to let businesses and other organizations know that regular inspections are going to be made. It has to set forth the scope of the inspection. The agency has to notify the business about how to comply with the statute and who is authorized to conduct an inspection. And it also has to limit the time, place, and scope of the inspection. So basically, an agency can't, show up at 3 in the morning and require an inspection if the business isn't operating at that time. It's got to be reasonable. The government can also create regulations that require private companies to warrantly test their employees. And so that is usually regulations have to limit the employer's discretion to test by specifying exactly when employees can be tested and under what circumstances. And this is another area where you're weighing the government's interest in protecting employees or protecting the public or both. That outweighs the individual employee's privacy interest. And again, the objective here has to be administrative. It can't be an intent to gain evidence for use in a criminal trial. And so this type of warrantless testing happens a lot if people are in like nuclear power plants again, or in certain other highly regulated businesses. You can have this warrantless testing. Okay, so to kind of summarize agency inspections, if a test encroaches on an expectation of privacy, it's a Fourth Amendment search. If the objective of the test is administrative, so you're not looking for a crime, then the test's just got to be reasonable. You don't need to meet the probable cause requirement of the Fourth Amendment. If the organization is not a closely regulated business, the agency must have an administrative warrant. Of course, if it is a closely regulated business, you don't need that warrant, but you do need that statutory scheme that kind of takes its place. And the more invasive the procedure, the greater the government's interest has to be in order to satisfy the Fourth Amendment. Okay, so that is it for agency inspections, and now we are going to move on to agency hearings, also called adjudications. Okay, so what is an adjudication? Really, it is just a fancy word for a trial. It's the executive branch agency's equivalent of a court trial. For the most part, we're going to talk about formal adjudications because those have a set form that agencies have to follow. Agencies also do a lot of informal adjudications, much in the same way that agencies can do informal rulemaking or formal rulemaking, same thing for adjudications. So the bulk of agency action is always informal, but the bulk of the adjudications that you read about are formal. And adjudications always involve issues of facts and interpretation of laws. So the same as at a trial, you're trying to determine whose set of facts is accurate and how the law or regulation addresses and gets applied to that set of facts. So more broadly, all agency proceedings that result in an order are adjudications. And that's just because agency action breaks down into rulemaking and adjudications. And so if there's no regulation issued, then technically it's an adjudication. So another way of answering that question is that an adjudication is the process of applying a pre-existing rule or some other standard of conduct to conduct that has already occurred. So you're looking at somebody did something, and now you're going to see if that something was acceptable. And generally, these do look like trials. They involve counsel, opportunity to present evidence, cross-examinations. The decisions have to be limited to what was justified by the hearing record, same as courts can't, suddenly take into consideration something that wasn't entered in a trial. Same thing for agencies. And then for formal adjudications, there's got to be sort of a written statement that the agency issues, and there's an opportunity to review that hearing in another tribunal. Usually another tribunal would be a regular court. So you can appeal an agency decision up to an Article 3 court. There's also a specific process set forth for adjudications, and so those include, you've got to give notice, there's discovery, pre-hearing conferences, settlement discussions, hearing, and then a decision. So that's kind of how it moves through the process. These are adversarial proceedings, just like a court trial. So parties get to present evidence, make arguments, call witnesses, cross-examine opposing witnesses, all of that. The procedures are more relaxed than in an Article 3 court. Federal rules of evidence don't apply. Federal rules of civil procedure don't have to apply. The Administrative Procedure Act does have some specific things to say about adjudications. Section 554 is adjudications just in general, and 556 covers hearings specifically. Now, it can sometimes be a little challenging to sort of determine what's an adjudication and what's a rulemaking. And there's a really good example in Denver. I've got these two cases here. They're two different cases, but they involve taxes that were levied on Denver residents. If the tax is levied on the entire city of Denver, that would be rulemaking. So the agency is using its regulatory authority. But if the tax is levied only on residents of a certain street, that's an adjudication. Rulemaking always has a vast application to many different people, and they don't have to be similarly situated necessarily. Adjudications involve a small number of people who were specifically affected by a certain action. So decisions in adjudications are based on facts, the facts of the individual case. Not on broad policy concerns. So the most common example is, if an agency thinks that a person or an organization has violated a regulation, the agency can require an adjudication. Basically, the agency is going to take the organization to agency court to determine if there really was a violation. Adjudications can be for violations of statutes as well. Congress can actually have agencies adjudicate portions of disputes that are going on in regular trials in Article 3 courts. In agency adjudications, there can never be prison time, only fines. But those fines can be seriously hefty. So agencies, often adjudications, they might be a decision to issue, suspend, or revoke a type of license or permit. And that could be a driver's license, a license to practice medicine, a permit to discharge waste, a permit to take on a threatened species. Those are all adjudications because they involve an individual person or organization. And a lot of adjudication occurs because an individual or an organization decides to protest some form of agency action. Now, usually those are government contracts, but in the environmental world, there are a lot of times that organizations actually just challenge the regulations specifically because of the impact on their business. So understanding the type of tribunal, whether it's Article 1 or Article 3, that's important for agency adjudications. So as a reminder, Article 1 of the Constitution sets up the legislative branch. Article 3 sets up the judicial branch, our federal court system. There are Article 1 tribunals, and these are the agency tribunals. There are also Article 3 tribunals, but they are courts. So Article 3 includes the Supreme Court, federal courts of appeals, district courts, full regular constitutional courts with full constitutional rights, what we tend to think of when we think of a trial. The executive branch is actually Article 2 of the Constitution, but we call agency tribunals Article 1s because it is Congress that created the agency, and it's Congress that granted those quasi-judicial powers to the agency. Article 1 tribunals, because they're not Article 3, they are fairly limited. They've got to be the agency jurisdiction. But there are a very wide variety of them, and we also do call them Article 1 courts. You don't always have to call them tribunals. So most agencies have their own Article 1 courts. There's the Armed Services Board of Contract Appeals, so that hears a lot of complaints from federal contractors, including EPA and USDA contractors. And then other agencies hear cases that relate to their areas of expertise. And that'll be permitted by their implementing statutes or some other statute that they are tasked with administering. We are mostly interested in the agency tribunals, but there are also a couple of other Article 1 courts, such as the U.S. Court of Federal Claims and the U.S. Bankruptcy Court, that if you stumbled into them, you would definitely think you were in an Article 3 court because they're in fancy courthouses and all that. But they are still not created by the Constitution under Article 3. So in a regular Article 3 trial, be it civil or criminal, your case is heard by a judge, and you stick with the same judge from start to finish, unless there's a magistrate in there, but we're not going to get into that. That's usually at the very start of things. In agency adjudications, you don't have a right to have your case heard by any specific agency official. So you can't force, the EPA administrator to hear your case. You also don't have the right to stay with the same hearing official throughout the whole process. It's not unusual for one agency official to hear the case and a different one to decide the case. You also typically, in agency tribunals, get an ALJ. That's an administrative law judge. And they do have the authority to do pretty much the same things that a regular Article 3 judge could do. They administer oaths, issue subpoenas, take depositions, basically have control of the hearing. They're the ones who make decisions, and they can also host settlement conferences and pretrial hearings, all of that. So they operate very much like regular Article 3 judges. So independence is the hallmark of the judicial branch, and that's why federal judges serve for life. It is not the hallmark of the executive or legislative branches, and ALJs are executive branch officers. They're not entitled to the same protections that federal judges get. Also, because they're executive branch officers, they work directly for the agency. And of course, there's a greater chance of bias if you've got to present your case to an agency and it's the person who works for the agency that's going to make the ultimate decision. And this is why Congress provides ALJs with quasi-independence. ALJs are assigned to cases in rotation. This keeps an agency from assigning a sympathetic ALJ to its case. They can only be removed for good cause, so they are shielded from agency retribution. If you are an ALJ and you rule against your agency, you're not going to be fired for that. Along the same lines, your salary is set by the Civil Service Commission, not by your agency. So you don't have to worry that you're not going to get a raise because you've ruled against your agency. And then they're also selected from a list of qualified candidates by the Office of Personnel Management, not by the agencies that employ them. So that creates a buffer so that ALJs don't feel beholden to their agencies. And that's good because fair hearings require neutral ALJs. So they can't have a financial stake in the outcome of the case. They can't have a personal bias, and they can't have prejudged the case. Now, there are times when an ALJ is permitted to have been involved in your case earlier and also be the hearing officer. But you can never have the same person investigate the case and also make a decision. The Administrative Procedure Act clearly separates what we call the prosecutorial function from the adjudicatory function. And that just helps keep a neutral ALJ who has not prejudged the outcome. This is just a list of some of the agencies that have tribunals where hearings are held. Pretty much all agencies have some type of ability to hold hearings, but it's the ones on this list that come up the most often. EPA has lots of formal adjudications, probably more than other agencies, because the EPA often has to fine companies for environmental pollution and violations of other environmental protection laws. And those cases always have to start at the EPA's hearing office. Now, like I said, if there's an adjudication from an agency tribunal and you don't like the result, you can appeal that to a regular Article 3 court. So regardless of which tribunal you're in, all agency hearings begin by providing notice to everybody. Notice, it's all about allowing the parties a sufficient amount of time to prepare their cases. And so notices fail if they are really vaguely worded or they're chock full of legalese so that just kind of a regular human wouldn't understand it. If they are not issued far enough in advance, that's usually got to be at least 30 days before the hearing, sometimes more. And notice also has to specify facts. It can't just tell a company, hey, you violated environmental regulation, because that doesn't allow the company to prepare for the hearing. So all parties have to be notified of these upcoming adjudications, and it's actually the APA that requires that. Parties have to be timely informed. They have to know the legal authority and jurisdiction under which the hearing will be held, and they have to know the matters of fact and the issue at law. So agencies can't surprise the parties. So like I said, can't contain bureaucratic gobbledygook, must be given to all interested parties, and must be made far enough in advance to allow the parties to adequately prepare their cases. So let me talk a little about interested parties. The official term is parties in interest, and this is not defined by the APA. So clearly, the parties that are named in an adjudication are interested parties. If it's state of Colorado versus EPA, then the state of Colorado is an interested party, and so is the EPA. But people who are not named can become interested parties by intervening in an adjudication. And a lot of times organizations intervene because they are suffering from some type of economic industry. And so if you think back to the GM versus FERC decision, that's a case where an economic competitor intervened in the case. So the natural gas line company was working directly with FERC, but then General Motors intervened because it was an interested party. It thought it was going to be negatively economically impacted by the decision that FERC was issuing regarding pipeline, this natural gas company. And that interest was enough to allow GM to force its way into a formal adjudication. And that's really just one example of how a party can intervene. We will talk later about intervening through consumer advocacy groups, and then as well as issues of standing to be a party. There are also non-parties who participate, witnesses, unnamed members of class action suits, organizations that file amicus briefs, basically friend of the court briefs that kind of get into their opinion as to how the court should rule. Those, though, are not parties. They are non-party organizations and individuals. Interested parties actually are named in the case or will have a specific negative impact. So subpoenas are orders that require a person to testify or send an official of that organization to testify or produce specified documents. And subpoenas are crucial to an agency's ability to enforce compliance with laws and regulations. So if an individual or an organization refuses to provide required information, maybe they're not submitting their reports on discharges, an agency can issue a subpoena to force the organization to provide that information. We call it compelling production. Agencies do not have inherent authority to issue subpoenas. They get that specifically from Congress. Congress has to do a specific grant of subpoena authority. That grant always goes to the agency head, but those people normally delegate that authority to sign subpoenas. And these are subject to the Fourth Amendment's relaxed requirements for administrative proceedings. The subpoena must be reasonably issued. You don't need probable cause, though. Now, agencies lack power to punish individuals who ignore subpoenas. The agency has to go to court to enforce that subpoena. And we will talk about that later when we talk about Article 3 proceedings. So after notice is given and the parties to a formal adjudication know what they're going to be fighting about in the hearing, they know the laws and regulations that are going to apply, then they go through a discovery process. And this is a pre-trial exchange of information. Discovery is designed to make the hearing fair and efficient and have everything go smoothly. Basically lets the parties gather information, and it tries to ensure that there are no surprises during the hearing. So surprises during trials, they make for good television, but in reality, it's terrible for agencies and for the parties because surprises tend to mess up the hearing and they might require everybody to start from scratch. So you definitely want to reduce the number of gotcha moments in a hearing, and that's what discovery is for. Discovery also works to support pretrial settlements. Hearings, because they are very much like full court trials, can be incredibly expensive, not just in terms of money, but in time and human resources expended. I am just now wrapping up an adjudication for my university, and it costs us about $800 per hour for our outside counsel. And we've had a team of 4 to 7 full-time personnel who have devoted 3 years to this, and everything else has been put on the back burner. So these are really expensive to go through a full adjudication. And that is why the Administrative Procedure Act wants to support settlements. It actually really tries hard to push parties towards a settlement. And that's done through discovery. And there are some specific rules that apply to discovery. The Federal Rules of Civil Procedure only apply in pieces to agency adjudications, but they do limit parties to requesting things that are reasonable. So reasonably calculated to lead to the discovery of admissible evidence. If your discovery request is unreasonably burdensome, the agency will not force the other party to go through it. If you asked for 40 years of receipts, that's going to be burdensome because nobody keeps 40 years of receipts. If you're going to demand the production of all documents related to the hearing within 7 days, that's going to be unreasonably burdensome, not only because the quick turnaround time is just not going to happen, but it's also a vague request. So discovery, you want to demand information that is fairly specific and will actually be useful in trial. You cannot get to privileged information during the discovery process. That's the whole point of privilege. So you're not going to get that. The APA does not talk about discovery, so agencies are not required to engage in discovery. And of course, the Constitution doesn't mention agencies, so the Constitution can't require agencies to engage in discovery. But the vast majority of agencies have created their own rules about the discovery process, and then they and the other adversary, parties who are against them in hearings, they all abide by those particular discovery rules. So there are several standard forms of discovery. There are depositions. These are oral questions that have to be answered under oath. All of the parties get to question, examine, and cross-examine the person being deposed. There are interrogatories. These are similar to depositions, but it's all written questions and answers. You're still under oath, but there is no chance to cross-examine the other party. And generally, interrogatories are the first form of discovery that you'd want to use because the answers that you get will help inform whether you want to have depositions or ask for production of documents. Because it's interrogatories, depositions, and request for production of documents that are the main types of discovery. Request for production of documents is exactly that. The other party has to produce the documents that you have specified. But you want to be very specific when you ask an adversarial party to produce documents, because as an attorney, I'll tell you one of the tactics we like to use is to provide so many documents that the other party can't figure out what they're looking for, they can't find it. There are other forms of discovery. There are requests for admissions where you basically put down something in writing and the other party says, yes, this is true, or no, this is false. And then there are the subpoenas, and those require non-parties. They can require non-parties to produce documents and testimony. So it's not just the parties to the case to which discovery applies. It can apply to non-parties as well. So before you get to the hearing, sort of parallel to the discovery process, there are also a variety of pre-hearing conferences. These are specifically authorized by the APA, and the intent is to settle certain issues and to simplify issues. Pre-hearing conferences are sort of a source of discovery because you're getting a chance to speak with the opposing party, and you can sort of collaboratively identify your sets of issues, agree on certain sets of facts or interpretations of law, review any evidence, and review the opposing party's witness list. But you don't necessarily get to do all of that. So there can be multiple sort of pre-trial hearings. It's not necessarily a one-time event. The more complicated the case is, and so environmental law is a perfect example of this, the more pre-trial hearings that you're going to get, or pre-hearing conferences. This is also a good time to engage in settlement discussions, because as we discussed earlier, the APA does require agencies to at least consider settlement offers. They can reject them after they've considered them, but agencies can't just outright reject your offer. In addition to sort of getting to settlement through an informal settlement discussion, you can also go through alternative dispute resolution. So you can decide that you're not going to go to the agency tribunal yet. Instead, you're going to do ADR. And that generally refers to mediation, arbitration, or binding arbitration. In mediation, you're sitting down with a third-party neutral, the mediator, and you and the opposing side, you go over your arguments about the facts of the dispute and how to apply the relevant laws. And then the mediator gets everybody to agree on a compromise solution, just through a plain old regular negotiation. Arbitration, on the other hand, is when you're presenting your case to a third-party neutral who actually makes a decision. It is a lot like a hearing, but with an arbitrator rather than an ALJ. Supposedly, it's an accelerated pace, but honestly, I don't particularly like arbitration. I think often, especially if it is binding and you're stuck with the arbitrator's decision, I don't like the concept of closing the courtroom doors to anybody, because we've got constitutional rights to access the judicial branch. So I'm not a fan of binding arbitration, but mediation and non-binding arbitration can be a quicker and easier way to settle disputes rather than going all the way through an agency adjudication. And fun fact, TV shows like The People's Court and Judge Judy are actually binding arbitrations. The show producers usually review small claims court filings and sometimes family court filings and see if there's anything that looks interesting. And then they'll reach out to the parties and ask if they want to do a binding arbitration in front of Judge Judy or whoever the judge is now at the People's Court. And so usually those shows also agree to reimburse both parties regardless of who wins the arbitration. So good deal for you if you are, in a dispute and Judge Judy wants to arbitrate, go for it, because you'll pretty much get paid regardless. So then there is the hearing itself, and this can be a full-on trial type hearing, just like you'd see in regular court. Agencies only have to provide that full-on trial type hearing if there are the magic words on the record after opportunity for an agency hearing. So that's a lot like formal rulemaking. You've got to have those magic words. Now, there are times when you might get the full trial type hearing, even if a statute does not contain those magic words. And that is if the Constitution's due process clause requires it. Because it's unfair for a party to be denied a full trial type hearing in certain cases. And if it's going to be unfair, then due process says, look, agency, you've got to provide this hearing, even though the statute doesn't specifically use those magic words. The formal agency adjudications are very similar to what you would see on Law & Order and every other type of TV show about lawyers that attempts to be realistic. You've got your opening and closing statements, presentation of evidence, examination and cross-examination of witnesses. You get to object to evidence that you don't think should be introduced. The only difference really is that rather than an Article III judge, you've got an ALJ or some other agency officer, but I'm just going to refer to them as ALJs. Now, the admissibility of evidence does differ at an agency hearing as opposed to an Article III court. In a regular court, the federal rules of evidence prohibit the introduction of untrustworthy evidence, irrelevant evidence, or evidence that is unduly prejudicial. Agencies don't have to follow the federal rules of evidence. They can listen to basically any oral or written evidence, subject to a handful of rules that do prohibit excessively repetitive evidence. So one of the biggest differences between Article I and Article III adjudications is that hearsay is permitted in an agency adjudication. You can't use it in an Article III court. Now, a lot of times we hear about hearsay, but many people don't actually know what it is. So the actual definition of hearsay is an out-of-court statement made by somebody who was not a party or a witness that is used in court to prove the matter asserted. So let's say you've got Joe, he's a witness, and he tells the ALJ, Bill told me that Nancy was in town. The agency gets to use this statement as evidence that Nancy was in town, even though Joe didn't see Nancy, and Bill, who's the one who said she was in town, did not get called as a witness. In an Article III court, that would never fly. If you want to prove that Nancy was in town, you've got to get Bill on the witness stand. What Joe says would be excluded as hearsay. But you can use this in an agency hearing. And again, this is just because the stakes are lower, which is why we've also got relaxed Fourth and Fifth Amendment standards for agency investigations. We've got relaxed evidentiary standards for agency hearings. It's also helpful because oftentimes in-house counsel can be useful at agency hearings, whereas those of us who operate in-house don't tend to do full litigations. So the relaxed rules of evidence and rules of procedure are beneficial primarily to the companies or the individuals, not to the government. Now, agencies do have to exclude certain types of evidence. You know, if it's irrelevant, it just wastes everybody's time, it's immaterial, or it's just repetitive, it's not going to get in, because there's only so many times that you need to hear the same information stated in different ways. So agencies do have one major restriction, which is that if they admit evidence that they should not have admitted, and admitting that evidence affected the outcome of the hearing, a court is just going to overturn the agency's decision. So agencies do need to be careful about what evidence they admit, but not nearly as careful as a regular court. Burdens of proof and standards of proof. These also apply to agency adjudications, quite similarly to Article III trials. Burden is just a reference to the obligation of a party to prove its case. And it's broken down into two parts, a burden of production and a burden of persuasion. So the burden of production lets you know which party has to produce evidence or raise a specific issue. then the burden of persuasion is for the party who has to convince the ALJ that they are correct. Normally, the same party has both burdens. If you think about a criminal trial, the prosecution has to produce enough evidence to prove its case, and it also has to convince the judge or jury that all that evidence adds up and it supports the prosecution's view of the case, which is that the defendant is guilty. Generally, the burdens are the same. They fall on the same party in agency adjudications. Social Security claims and veterans claims are a main exception to that. But so normally, burden of production and burden of persuasion fall on the same party, usually the party who is bringing the suit. Standards of proof are related. By how much do you have to meet your burden? Like, what's good enough to win the case? And at agency hearings, it's a preponderance of the evidence. So that just means that it is more likely than not that the plaintiff has proved her case. This can be as little as, the plaintiff 51% probably wins and the government 49%. That is still a preponderance of the evidence. Now, in agency hearings where there are civil liberties threatened, which primarily is in the law enforcement and corrections fields, then you do need to show clear and convincing evidence, and that's what the agency would have to show at a trial to say, put somebody in a supermax prison or put them in solitary confinement or deport them from the country. Clear and convincing is more than just that 51% preponderance of the evidence, but it is less than the overwhelming beyond a reasonable doubt that we require at criminal trials. Congress is the one that specifies what standard of proof the agency has to meet, but it's going to always be one of those three standards: preponderance of evidence, clear and convincing, or beyond a reasonable doubt. So finally, you get to the decision, obviously a very important part in both an agency hearing and a court trial. Unlike in an Article III court, the Administrative Procedure Act gives parties the right to submit their own proposed decisions. Usually we call that a proposed finding of fact and conclusion of law. And before an ALJ issues a decision, he or she hears from both parties and kind of weighs what the parties believe are the appropriate findings of fact and conclusions of law. In agency adjudications, ALJs issue a initial or recommended decision, and that decision becomes final if the losing party does not appeal. The only time an agency will issue a final decision immediately after the hearing is if the head of the agency is the one presiding over the hearing. That almost never happens. So the vast majority of agency adjudications, the decisions, formal or informal, they are recommended decisions that will eventually become final. So in a formal adjudication, the APA does require some specifics. The ALJ's decisions got to be part of the record. And that's necessary because if somebody appeals into a regular court, the court has to be able to review the record. So the APA requires that the ALJ provide written statements of findings of fact and conclusions of law, and basically a reason for those findings and conclusions. So that's very much like a court decision where there will be a holding and then rationale. And this provides accountability for ALJs and agencies because they are committing these decisions to writing. It tends to improve the ALJ's decision-making process because they actually have to think through and kind of do a reasoned analysis of the hearing. These decisions also educate the public because we can read them, just like with court opinions, and they can provide some precedent so that individuals and organizations can kind of make educated guesses on how an agency is going to rule by taking a look at past decisions. And again, they just allow for meaningful judicial review, which we will talk about later. So they've got to, again, ALJs, they've got to find facts, reach the conclusion, render a decision, explain it, and that's all got to be in writing. Now, in informal adjudications, which again is the vast majority of adjudications that agencies are involved in, the statute doesn't contain the magic words. The due process clause doesn't require a full trial type hearing. So in that case, the ALJ just issues prompt notice and a brief statement. A lot of times this is a brief statement of the grounds for denying a claim or approving a claim. But whatever the primary question was in the hearing, that's when the ALJ lets the parties know, I've made a decision, and in brief, here's who won, and quite briefly, here's why. So in formal adjudications, the ALJ's got to issue something that's very similar to a court opinion. But in the vast majority of adjudications, because they're informal, you just have to be notified and given a brief explanation. Okay, so that is it for our discussion, our lecture. Your second case brief is going to be due. And also, if you haven't started reading a civil action, I strongly recommend that you do. So thank you very much for listening. I will see you on the discussion boards.